Hello, good morning, good afternoon, everyone. I'd first like to say thank you for attending our webinar today. Today we have a presentation from Dr. Neil Websdale presenting for National Domestic Violence Fatality Review Initiative. The presentation is called Intimate Partner Violence Risk Assessment and Family Court. This webinar will be recorded and it'll be distributed to you next week via email with closed captioning. If you're having any technical issues, please use the chat pod on the lower right side, or you can contact me at chaira@nau.edu. If you have questions or comments, please use the chat pod in the right corner. Thank you, and we shall begin.
Okay, thanks, Ray. So welcome, thanks for joining us. I'm going to talk about intimate partner violence risk assessment and family court. And I'm going to do this in two ways. One, I'm going to do it as a fatality reviewer who's reviewed many cases over the years of intimate partner homicide and other domestic violence related deaths. So I'm going to talk about this from my experience of basically 25 years of reviewing these cases, a number of which involve the family court system. And then I'm also going to review some of the research on these issues. So I'm going to speak to as a researcher. So that's my focus. I will be, I can't click, Ray, for some reason. Okay. I'll be focusing on four main areas in this presentation. I've just outlined them here for you. I'm going to talk about some sort of generic perspectives on family court. These perspectives I've sort of congealed over the years listening to folks in court systems. I've also got some of these ideas from a commission that I sat on in the state of Arizona, at Arizona Supreme Court Commission, on mental health and domestic violence in the courts. So I'm going to talk about various perspectives on family courts, talk about family court itself and IPV and risk assessment and what some of the presenting issues are. Then I'm going to give sort of a capsule presentation on the sort of behaviors and forms that we see in intimate partner violence cases, and particularly focus on those behaviors and forms of violence that may be of particular concern to court systems and that may result in particular forms of harms that we want to avoid. And then finally I'm going to talk about the very specific issues of using IPV risk assessments in perhaps a family court arena. So that's the outline. I want to start by saying that, again, I've picked up these perspectives over the years, so they're stereotypes, they're generalizations. I don't wish to suggest that they're written in stone. There's a lot of variation in the court systems across the country. But first of all, I think it's fair to say that in many instances and in many states, assignment to a family court for an officer of the court, judge, is not necessarily a popular assignment. Those courtrooms are often crowded. They have self-represented litigants. In Arizona, for example, probably 80% of them or more of those litigants are self-represented. They don't have counsel. Therefore, they don't necessarily know the rules of procedure and how things work. In many courts across the country, the litigants are often not native English speakers, which adds another layer of complexity sometimes into those cases. The dynamics in domestic violence cases are very complicated, and at times human behavior can appear to be irrational. I've had a number of judges over the years tell me that the parties wouldn't even be in family court if they were rational human beings, which is a bit of an extreme position, but nevertheless, those sentiments exist. And certainly, it's hard for us to make sense of these complicated cases using the language of the discovery of truth through the court system and the resolution of conflict by freestanding adversaries presenting positions and then sort of rationally reaching a conclusion. These DV cases, with their incredible power imbalances sometimes and complicated dynamics, don't necessarily comport with that model in the courtroom. And they, of course, don't necessarily comport with the model in the criminal court arena either. but those disconnects are important observations. It's also the case that many litigants do not come with evidence. They come sometimes with broken relationships, or maybe relationships they want to heal, but they may not come with evidence that can be used by the court to make determinations. These things are also very emotional cases often, whether they be divorces, child custody, supervised visitation, paternity issues. These are very much emotionally charged cases. There's a lot of drama in them. There's a lot of potential threats, perceived danger for the parties, including the judges, including the attorneys, custody evaluators, and of course the litigants, the parties themselves. So there's this sense of danger that pervades these cases sometimes. There's this looming threat potentially, given the emotionally charged nature of the case. On top of that, there may be reasons why litigants don't want to claim that intimate partner violence or domestic violence has occurred, because they know, or their attorneys know, or they've been advised that those claims can present peculiar difficulties within the family court arena, especially if they're claims that are being made without any accompanying evidence. So there is the question at the level of the court potentially, are at some level the parties scamming? Are they using, for example, orders of protection or these claims to make a case for themselves for custody or for a beneficial outcome in some way? If we throw on top of that the fact that family court cases per se take a long time in general to resolve for lots of complicated reasons, often related to due process, but not necessarily so sometimes, this too adds to the frustrations. And I think everyone on the call knows these things, but this really heaps on the tension and makes handling these cases in court sometimes extremely perplexing. So I now want to talk about a few what I call socially situated perspectives on the court system. I want to start by talking about what domestic violence advocates sometimes see, what domestic violence coalitions, maybe at state levels, see, and how they work with their own clients, victims, alleged victims, and what they think of some of these systems. There are common claims, and again we know this, that judges need to take domestic violence allegations seriously, and domestic violence advocates sometimes don't feel that judges do that. Now, whether the judge is taking the case seriously or not is not easy to read, given the judge's concern with integrity and impartiality and objectivity in these cases. So a neutral read could easily be misconstrued as something that is dismissive or uncaring. So taking allegations seriously is a claim often made. Attorneys, as I mentioned earlier, sometimes tell clients not to mention any domestic violence because judges don't want to hear about it. Some attorneys have told me, family law attorneys, that judges can even become hostile when one parent starts to talk about domestic violence, even potentially shut down the conversation. So victims have this fear sometimes, or alleged victims have this fear, that the court might worsen their plight. And this could all be construed, potentially, as a lack of compassion on the part of the court. So it could be, too, that there's a need to have criminal allegations considered in family court cases, that there are parallel criminal issues proceeding in the courts that the family court may not know about that need to be heard. We've heard cases, for example, of judges denying relocation requests for victims of domestic violence, or even ordering victims in address confidentiality programs to reveal their addresses in open court. The extent of this, we don't know. This happens, it's anecdotal evidence, but it's an important concern when protecting someone's privacy rights, confidentiality rights, and working a safety plan with them. So from the advocate perspective, from coalition perspectives, often when domestic violence is identified, it ought to become central to any family law case, a central phenomenon in that case. One of the potential problems with that issue is that if you just use the language of domestic violence to describe this plethora of case types, you end up including or arguing that DV should be central whatever form it takes. And that might be problematic. And we'll talk a little bit more about how the risk literature and how triaging cases may enable us to be more discerning and not treat that DV all as one thing. Clearly, the cost of litigation is excessive. It's a major issue in these cases. The cost of hiring experts is out of the reach of the vast majority of litigants in these court systems. Now, many victims or alleged victims perceive that domestic violence cases are mishandled actually before they get to the family court. They may have been subject, for example, to a dual arrest, where they deemed that to be inappropriate. They may have been involved in a case where the police failed to gather adequate information in, say, an on-scene DV call, maybe failure to take follow-up photographs, or to do what they were supposed to do, or to screen for risk, or to ask the right questions. So there could be a grievance from the criminal arena that leaks over into the family court arena. There are claims potentially of the inconsistent application of law. I've heard stories of, for example, one judge requiring 3 documented incidents of domestic violence in the form of police reports before considering the issuance of an order of protection. Now, the statute in this particular case where this happened does not require any police reports. Only one incident needs to be alleged. But these kinds of things are stories. Are they anecdotes? Are they accurate? We don't know, but they're real, sometimes for the people who are party to them. There may be no consequences for violations of order of protections. And again, we'll see many examples of this. We see, for example, police turning up at the scene where she's invited him over, for example, and he's the subject of the order, she is not, and maybe she's invited him over to, I don't know, have sex, or maybe to borrow money, or who knows why, maybe for companionship or whatever. In breach of the spirit of the order, but not the letter of the order, he's subject to it. So there may be no consequence for the violation when the police turn up and see that situation. So there are lots of complexities here to this that concern victim advocates. There is a concern too that in family court cases, attorneys encourage actual dismissal of orders of protection, because those orders of protection may be seen potentially as forms of manipulation. There are concerns that judges sometimes give parenting time to domestic violence offenders. Now, this again is a concern of advocates. What is the extent of the domestic violence in those cases? What is the appropriate level to cut this contact time off, to reduce this contact time? Judges have, we've heard, been ordered victims to take a child to prison to see an abusive parent. So the questions advocates often ask, or coalition members often ask, is, has the offender taken steps necessary to be allowed parenting time, to be an appropriate parent, taken steps to curb acts of violence, maybe acts of intimate terrorism, or maybe other steps, maybe for mental health treatment, maybe for substance abuse treatment. According to coalitions, maybe the unsafe parent or prove they are safe. That's a possibility. That's a question. Clearly, there's a lack of legal assistance in domestic violence and family court cases. Advocates try to help victims when they prepare for court. Clearly, the court itself, in its own stance, is neutral. Court clerks are neutral. Those at windows issuing orders of protection, or at least the paperwork to file for the orders of protection, are supposed to present as impartial. So again, there's the appearance here of the court not working for or being sympathetic to the plight of victims or alleged victims. And again, parenting coordinators themselves, family therapists, others may be untrained in understanding domestic violence. So if we swing now and we look at, say, for example, the perspectives of family court judges, we may see some very different perspectives. And it could be that allegations of domestic violence can become an abuse of the legal process. And, the judge is locked into the statute. There are many good reasons for that. So the judge adheres to the statute and needs evidence. So the allegations could be problematic. Some judges feel as many as half of cases, an order of protection is an attempt to interfere with parenting time. Now, I don't know the full extent of the research on this, and we clearly need more. But judicial perception of the use of orders of protection is an area that we need significantly more work in. Again, for the court, sometimes this comes down to he said, she said, especially if there's no independent evidence of domestic violence. It could be, too, that engaging in parental alienation, in other words, turning the child against the other parent, alienating the other parent, using the child in a manipulative way like that, could itself lead to domestic violence. So, for example, in cases where mothers maybe or fathers call Department of Child Services, Child Protection, make false allegations. If the father is giving up parenting rights because of her false allegations, these are potentially hugely problematic. The last request for technical assistance I got through our National Fatality Review website was from someone who was very concerned about the abuse of fathers by mothers in custody disputes and false allegations of domestic violence. So these are issues that are on the surface that we need to deal with and acknowledge at the front end. It can be that judges are unsure about whether superior court judges can amend existing orders of protection from limited jurisdiction courts. There might be a lot of uncertainty, a lack of training in those areas. There may be difficulty getting one court to transfer an order of protection to another. Clearly, in many jurisdictions, especially smaller ones, there's a dearth of resources. They have fractured behavioral health services, sometimes even no roster of service providers. So these are very, very big problems. If we layer on top of that many of the parties are poor, or indigent, adjacent, or nearly poor, sanctions are limited with poor populations. So if the party is non-compliant, what do you do? Where do you go? It's also the case that parties involved in family court disputes won't agree to the use of parenting coordinators. If one parent is identified as dangerous, then what information ought judges be looking for? What further assessment could be made? Could judges mandate treatment? Does that treatment work? What does that mean to the court? Does the statute say that parenting time is prohibited if there is actual domestic violence? Or does that domestic violence have to reach a certain level? It must be taken into account, but if there's no statutory hammer, that influences the way in which the judge may decide in relation to the nature of DV. So is there a requirement, so for example, as there is in Arizona, about significant domestic violence? What's the definition of significant DV? Does that mean intimate terrorism? Does it mean coercive control? Does it mean something else? Or is it defined deliberately, vaguely, to enable judges to use their discretion? These are complicated issues. Clearly, most litigants, as I've said before, can't pay for assessments. They're in crisis, they're untreated, they're unmonitored, they're often unmedicated. There are mental health problems, substance abuse issues. These compound these very stressful junctures in people's lives. Some judges complain about false allegations of mental illness against family court litigants. There's confusion about when children can be included in orders of protection. Now, if we move from judges to family law attorneys, DV allegations in these cases for family law attorneys may be very different. For example, if someone breaks a cell phone in a dispute or an argument, these may be levering maneuvers in some cases. These may be tactics that family law attorneys can use. Orders of protection can be used as a sword and not a shield in these cases. So there is a judicial suspicion of this, and when we have family court lawyers, sometimes whose pay relies on the resolution of these cases or the time they spend on these cases, this too can present problems. The attorneys, remember, don't necessarily need to find the truth, the judge does. The attorney counsels the client on what their client needs to do to be successful in court. So these are gray areas. So as a long-time skeptic in the field of risk assessment, but as someone who has been doing a lot of work in risk assessment, community-informed risk assessment, I want to now turn to the second part of this 4-part presentation and talk a little bit about the family court, intimate partner violence and risk assessment, and basically what we know to date. And just to say a few words about this that are really obvious, risk assessment tools are not evidence. Courts have to adhere to statutes. If a police officer deploys a risk assessment tool after there's an arrest being made, for example, in a domestic violence case, and asks a series of questions, there may or may not be evidence to back up the statements made by the victim, but those are allegations at scene, and those are allegations that, for example, in our state in Arizona, those allegations can flow to the judge, which the judge needs to consider at the initial appearance of the offender. But these are allegations. There may or may not be evidence to support them. Risk assessments really should not be used to either grant or deny protective orders or to determine guilt or innocence. And by risk assessments, I'm talking about risk assessments alone. Research into intimate partner violence risk assessments has just started. We've just begun this risk revolution. It's in its infancy, and we need to use tremendous caution in these areas. These risk assessment tools may be very valuable, but they come loaded with a lot of baggage and potentially a lot of due process issues, and potentially pose a threat to the rule of law. So we have to look at them bearing in mind those pros and cons. They may be able to create a shared language for the court, which may be useful. May be useful that that language is continuous with the language that's used in the criminal arena and the community arena in general, in public health facilities, with advocacy or whatever. But we cannot take the existing research literature for granted. We cannot assume that it's correct, authoritative, or valid. It's in its infancy. The researchers know this. Some are more reluctant to talk about it than others. But the bottom line is that we're learning how to do this. We've got some good information on what precedes intimate partner homicides, but many of those things also occur in other cases. So this is an example of some research which I like a lot, which was done in New York State, which gives us a sense of some of the presenting issues. This is Nicole Hadid's research in 2012, and which I've got a full reference to in my footnotes here. But they sampled 169 women in upstate New York. And what they did was they compared scores on Jacqueline Campbell's danger assessment with protection order petition data. And they compared the sets of information. So in other words, they administered the danger assessment, the DA, and they compared it with what applicants, women, had written in orders of affidavits in order requesting orders of protection, to see what level of detail there was and what was missed. And this research was done with a view to getting a sense of what doesn't get included, but what might be included if we had some kind of risk triaging mechanism. So this was a very clever, innovative piece of research. So for example, on the drug and alcohol issue, drug and alcohol use was much more frequently reported on the danger assessment. You can see 46% of respondents answered yes, versus on the protection order petitions or affidavits, which only 12% included that. With sexual assault or rape, much more frequently reported on the danger assessment, 45%, versus merely 5% in the protection order petitions. And these percentages, the precise percentages don't matter that much. What does matter is some of the glaring differences between the two sources of information, or these ways of knowing about what might have happened in these relationships. So the potential threat of perpetrators or alleged perpetrators to harm their children in the danger assessment, 30% of women identified that tendency, whereas in the petitions only 10%. Now it could be that with that particular variable or risk marker, the women were concerned that if they did report that it would draw the attention of Child Protective Services. So that's one possible explanation for that. Glaringly, and I think that this next variable is very significant, and that's the prospect of suicide attempts. With the danger assessment, 41% identified suicide attempts, whereas in the petition, only 1% noted that. With threats of suicide, 41% versus 8%. That's a glaring difference, and suicidality is a serious issue in these cases, and it is a frequent theme in these cases when these relationships are dissolving, when there's a lot of tension. These are dangerous times in these relationships, and the suicidality is an important factor that we need to know about. So Nichols, Hadid and co. concluded that judges were making decisions regarding protection order provisions and custody and visitation matters without vital information related to perpetrator, drug and alcohol use, suicide attempts, threats, and sexual violence. And I should say that that's their conclusion. Their conclusion, I think, would be better worded as, and it may have been worded as this, I'm just not writing it down properly, alleged vital information. So let's turn to some of the case law now, just recent case law, and get a sense of what that helps us with. The Pettingill case in Kentucky, which I've got the full reference here to this, this was a case decided originally by Judge Jerry Bowles in Kentucky, and this eventually ended up going to the Kentucky Supreme Court. In July of 2013, Sarah Pettingill filed a domestic violence petition against her husband Jeffrey, from whom she'd recently separated. Sarah said she feared Jeffrey's unstable and controlling behavior and his violent tendencies. There was abuse of a pet in front of the child. She had photos to prove he'd obtained ammunition, but she did not know where his gun was located. And she obtained a temporary order of protection served on Jeffrey based on that information. Both parties appeared at the full order hearing with counsel. Both testified that Jeffrey had never laid a hand on Sarah. So both parties are not claiming actual physical violence. The Kentucky court can issue a civil DV order if it finds from a preponderance of the evidence that an act or act of DV and abuse have occurred and may occur again. So that's the standard. Kentucky Rule of Evidence 201 permits the trial judge to take judicial notice of adjudicative facts that are not subject to reasonable dispute, i.e., for example, those from unimpeachable sources. So those highly reliable sources. So judicial notice of that. In other words, they can take that as fact in evidence presented to them. So this would include examples I've listed below in the second bullet. The court agreed with Jeffrey that lethality factors are not the type of facts that may be properly taken by judicial notice. In other words, the court recognized that these are allegations, not evidence to be taken by judge. Lethality factors or lethality predictors for IPV are not facts but risk factors, used by courts, law enforcement, and others, used by social scientists. The court confirmed that Judge Bowles did not take judicial notice of those lethality factors and interject them improperly. So in other words, they relied on the fact that Judge Bowles had 20 years of experience working on the fatality review team in Louisville He had a very fine understanding of risk factors in domestic violence cases that ended in homicide. So he used his judgment and used that to partially form his opinion in that case. So we should say that the US Supreme Court on risk assessment, the original precedent case on that is the Barefoot Estelle decision of 1983. And you can look that decision up, but basically that decision held that even although danger assessments are more often wrong than not, they should nevertheless still be admissible into the adversarial process. And that was a case, that was a death penalty case, the Barefoot Estelle case involving a police killing. So the standard is relatively low. In other words, we don't have to have perfect prediction. We don't have to be able to predict 100% of these cases. And in fact, the amicus brief for the defense in that case, in Estelle, held that only in about a third of the cases were psychiatrists' predictions of danger accurate. So that standard for a third in sentencing is pretty reasonable standard. So, you know, the Supreme Court precedent on the risk assessment stuff, and we look at the Pettingill case and the OP case, it does give us a sense of the way in which these risk assessments may be admissible within certain boundaries, and what those boundaries might be, and some of the cautions we might have to use. So let me go on now and come into the third section of the presentation that I wanted to talk about. And this concerns sort of an overview of intimate partner violence in general and some of the stereotypes out there that we have to deal with. And I mention this in the light of family court hearings with family court judges who may not be trained in the intricacies or the details of intimate partner violence and the dynamics of those cases, and may have to rely on evidence and statute, and therefore find these very complex. So, first of all, the standard approach that we have in the domestic violence field over the last 30 years is this sense, on the one hand, that we have a virtuous female protagonist, and on the other hand, this sort of one-dimensional male villain, usually a male villain, sometimes female. But this is a problematic binary, because it denies really the complicated humanity of men and women as they come into court, particularly in family court, in stressful times when they're going through a breakup, when they're going through a separation, etc., etc. When there's a lot at stake, including potentially the specter of poverty, losing contact with one's child, etc., etc. So people don't behave as per this binary, and we shouldn't expect to see that. We know that there's a lot of denial in these cases. Victims are ashamed of who they are. They'll often hide their abuse, especially the more grievous, personally shameful forms of abuse. So there's a lot of denial, and there's a lot of minimization from perpetrators as well. Perpetrators minimize their violence, they minimize the impact of their violence, just as many people minimize the impact of their behavior when they're in situations where they're in an uncaring relationship with somebody else. The appearance of dishonesty in these cases is profoundly important. First of all, it's common. We know that in the criminal arena, victims recant. We hear numerous stories of victims telling prosecutors that they hate them, even although they may have agreed to pursue a prosecution earlier on. They change their mind. They request dismissal of charges. They'll sometimes refuse to testify. Sometimes they'll even testify in a criminal trial on the part of batterers. So this can be very, very confusing, and these dynamics carry over sometimes into the family court arena, where the behavior is presented as very, very confusing. And just to try to offer some kind of explanation here, we may be dealing with complicated trauma that people have had in these domestic violence relationships, especially the particularly heinous ones. So the particularly heinous, dangerous cases that we refer to as intimate terrorism, coercive control, may exhibit long-term complex trauma on the part of victims. So there'll be a lot of confusion, befuddled thinking, actual dishonesty, using dishonesty as a survival strategy, etc. The court may not like that, the court may frown on that, and so in many ways it makes their life extremely difficult. But for victims, we're talking about this disconnect between the adversarial, rational basis of the family court system and the truth-seeking versus their own subjection to power relations and humiliation in their relationships. And we also see this complex trauma often on the part of men who've abused or men who are in domestic violence relationship where there may be mutual violence and abuse between the parties. So very complicated. There may also be witness intimidation in these cases, very subtle. My colleague Evan Stark sometimes refers to this intimidation as being invisible but in plain sight. In other words, we know it's going on. The victim knows it's going on from the glance, the stare, the stink eye. The judge may not see this, but it's there. What we can be sure of is that even if the court, or even if victim advocates, or even if the cops see victims or alleged victims appearing to comply with the wishes of batterers, they may not necessarily be complying. They may be going along to survive, to protect their children, to strategize, to do whatever it takes to survive. So what we see is what I refer to commonly as the counterintuitive or the seemingly counterintuitive behavior of victims. We see the same with perpetrators in some ways, although for different reasons. Victims won't report the abuse. They won't necessarily leave or cooperate with the prosecution. They fear losing their kids. They have hope for the relationship. There's a stigma, clearly a stigma attached to divorce. Leaving itself is not easy. All these things present as part of family court dramas. She's indecisive about leaving. She's going to be affected by all kinds of complexities. And we see, losing home, possessions, job, father, etc. These are all deeply disturbing developments. To boot, they may be unsafe. They may be dealing with batterer remorse, attempts to beg forgiveness, promising to change, etc. We may also see batterers blaming victims, gaslighting them, as it's sometimes referred to, try and drive them crazy, depict them as mentally ill, this and that. There are lots of different ways in which this works out. But we also see by victims sometimes taunting and potential provocation by them. It could be inadvertent, it could be deliberate, but this adds to the stir and the mix. So these are the complexities that we see. We see these complexities in the serious homicide cases, and we see them in the lower level cases. But this is the behavior that judges will sometimes see, that the court will see, that people at court clerk windows who give out forms for affidavits, will see sometimes too. So this is what presents to a court system designed to gather evidence, to weigh it, and to weigh it rationally. So the dissonance, the disconnect, is alarming and disturbing. Now, if we add to this the dangerous behavior of some offenders, most of the dangerous cases involve what Michael Johnson has referred to as intimate terrorism. We're rarely dealing in the dangerous cases with what some people refer to as situational couple violence or sort of incident-based violence. We're usually dealing with violence and abuse over a longer term period of time. Now, the researchers who've worked on this, and there have been many, are pretty much in agreement that there are clusters of risk markers that occur in the death cases. And we've known this since the 1950s. We've got a very large literature on this. The problem with the literature is that those clusters of risk markers also occur in other intimate terrorism cases, for example, that do not result in death. So drawing a sharp distinction between death groups and near-death groups is very, very difficult for predictive purposes. We have research that compares the two groups, but for predictive purposes, to triage cases, to alert, to disproportionately allocate resources We do not have that much research at this point to help us do that. The situational couple violence involves less of an attempt to control. So we're talking here about incident-based stress, anger, release, arises out of particular situations. So I don't want to belabor this too much. I know that we've covered this ground in other webinars. Clearly, with the lower level violence, people can still get killed if the violence takes a certain form, but typically the violence is less severe. We're often dealing with offenders who are younger, immature, poor communicators, they abuse drugs and alcohol, poor anger management, etc., etc. And with the lower levels of violence, we see a lot of violence committed by women in relationships. And it's not violence that is committed in response to violence necessarily by men who are aggressors in the long term. This is violence committed back and forth, tit for tat, this and that, this incident, that incident, with booze, without, maybe with some mental illness, maybe without, but nevertheless, there's a lot of it and women do it. So this confuses the family court scene. What are we dealing with the DV? If there's an allegation of DV, what form does the DV take? We have to be discerning about the form the DV takes. Otherwise, it collapses into he said, she said, and without the evidence and without the specifics that go with that evidence. For example, broken bones, x-rays, police reports, photographs, petechiae in the eyes, or thumbprints behind the ears for strangulation stuff, something like that. So the social surveys on this, the research on this is clear. Situational couple violence, the lower level, men and women engage in roughly similar amounts. It may be 60-40, who knows, who cares. That's significant. The court sees it. The key is the dangerous stuff, the more likely stuff to be dangerous, more social harm, greater harm to the community, greater long-term harm to the kids, is the intimate terrorism stuff. And trying to tease that out is where the risk assessment stuff may come in much more handy. And the intimate terrorism appears to be profoundly gendered. Men do it more than women, whether it's 90-10, 80-20, who knows? We don't necessarily know. There's a lot of research out there that pushes this one way or the other. Michael Johnson used to refer to this as patriarchal terrorism, linking it to patriarchal relations. That turned out to be more problematic. Now it's seen sometimes as just intimate terrorism. So here we've got abuse, controlling behaviors, attempt to control, according to Johnson, over a long period of time. Sequential, cumulative crimes of accumulation. Regardless of the gender ratio, whether it's 90-10 in favor of men doing it, whether it's 80-20, who knows, but regardless of the gender ratios in intimate terrorism, most agree that women are more likely to receive the more serious injuries. Men are more likely to externalize their rage and their shame in violence and to use more heinous, vicious, injurious forms of violence. We know this. This is well documented. Women are more likely to report depression, stress, and suicidal thoughts and attempt as a consequence of IPV than men. So they're going to internalize, although they won't complete suicides, perhaps because they're less willing to use handguns. It is also the case, though, as numerous researchers point out, that men are probably less likely to report certain assaults by their partners, maybe. So what are we looking at within the ranks of intimate terrorists? We're looking at two broad kinds that the risk assessment literature may be able to give us some resolution on, that may be very helpful in family court. The intimate terrorism stuff sometimes is referred to as coercive control. Evan's work on coercive control certainly is also well documented in the movement. It's been around for 30 to 40 years. So we have a number of typologies out there, and time precludes me addressing all of these. But a few words about the dependent intimate terrorists, which are the vast majority. Probably 80-85% of intimate terrorists are what we would call dependent intimate terrorists. In other words, coercive controllers who also suffer from a lot of abandonment anxiety, a high sensitivity to rejection. They're highly dependent, vulnerable, as well as abusive, bullying, terrorizing, etc. So we see dependent intimate terrorists, we see antisocial intimate terrorists that may qualify for a diagnosis of antisocial personality disorder, may qualify for what some people might see as psychopathy. Both of these types are impulsive, accepting of violence, hostile to women. They tend to be misogynistic. They've got very traditional sex role stereotypes in their heads. There's some interesting research on this, and one interesting typology on this is Jacobson and Gottman's work on pit bulls and cobras, which I'm sure many of you have seen, but When Men Batter Women is the title of the book. And here we talk about, or they talk about, the way in which physiologically batterers who are pit bulls, who are hostile, who are angry, but who are also vulnerable and dependent, the majority of batterers, are actually physically in turmoil when they're arguing with their partners. So the antisocial intimate terrorists are rather different. They're not necessarily particularly jealous, or not necessarily even particularly dependent. They're antisocial in general. They may be violent outside of their intimate relationship. So their violence often escalates, as per the cobra's violence, very quickly, very suddenly, and the strike is different. So it's not as if they're fuming anger all the time. So these typologies present, and the idea of trying to use risk assessment, maybe in a family court setting or other setting, to unravel some of this stuff, is the stuff that we want to get at. Can we do that? How might we use a risk assessment to get at someone who's an antisocial intimate terrorist, for example, or an antisocial coercive controller? So we also have to raise the question of, are there other aspects to this that we're missing that matter when we look at these forces and explanations? To say that the violence of the man is just a product of his power and control is problematic, given that the danger seems to escalate when the power and control is ebbing. So we also need to ask, are there unconscious drives at work here, or biological forces, forces that we can't understand? And if there are, what are the implications for the court, the family court, or indeed the criminal court, in terms of premeditation and rational acting and thinking these things through? So in general, and I'm running tight for time, so I'm going to pick my pace up a little bit, but the telltale signs that we condense from the research and from our fatality review work include the following. And I'm just going to lay some of these out before I go into some of these in more detail, but it seems to the researchers, and the fatality reviewers for that matter, that a prior history of IPV is the single most important risk marker that we have. And given that prior behavior is the best predictor of future behavior, although a very imperfect predictor of future behavior in the social sciences in general, past behavior predicts future behavior. We see this with suicide, we see this with drug addiction, we see this with intimate partner homicide to some degree. But the word imperfect is important. But the prior history is not a prior history necessarily, as I said earlier, of slapping and shoving. It may entail a history of weapons use, of strangulation perhaps, of serial strangulation perhaps. Our risk assessment screens might need to get at those things. The violence may be escalating. Remember, these are cases that unfold over time. So the element of time, the longitudinal nature in the dangerous case, is important. So if you've got a family court case that is unraveling over time with persistent themes of violence, it may speak to one of these more dangerous kinds of cases. So, attempts to control, various emotional harms, beating during pregnancy, previous attempts or threats to kill. And with previous attempts to kill, according to Jill Messing's latest research, being more important and pressing, obviously. For sex, entrapment, hostage-taking. Does the victim think that the perp is capable of killing her? Sophisticated stalking. We see this in a number of family court cases. Very difficult to track. Sometimes very sinister. Sometimes the stuff that one might strategize over to maybe get a stalking prosecution going as opposed to a misdemeanor DV prosecution, but tricky and difficult to do. So those elements of prior history are things that we might want to consider at the family court level, that people might want to consider when documenting abuse in their past, filing affidavits in request of orders of protection or petitions. So those kinds of things matter. Separation or emotional estrangement in the relationship. If we know the psychology of the batterer, if we know that 80-85% of these folks are pit bulls in the sense that they're vulnerable and dependent and they're threatened by her moving somewhere else. They're extremely sexually jealous, but they're also threatened at the same time. The emotional estrangement and separation becomes more dangerous because it's a threat to the identity of the abuser. We may not see the same thing with the psychopathic or antisocial personality disordered batterer. So again, these are things to weigh in different contexts, in different cases. We may see different things. Extreme jealousy linked to violence. Dr. Jacqueline Campbell has identified this as a very significant risk marker. One that I always think is very important is depression and suicidal potential, particularly institutionalization for suicide attempts, suicide plans, medication patterns that comport with that intervention, etc. Drug and alcohol use. The alcohol, of course, compounds depression, affects behavior, maybe lowers inhibitions. The drug abuse is important in the case, but it's also important if the perpetrator is the supplier of the victim's habit. So again, we see a number of complexities here. Stepchildren in the home. Are they the stepchild? Is this the stepchild, for example, of the woman from a previous marriage? The abuser wants his control, his access to her to be not only current and future, but potentially retroactive as well. That's how bad that need is. So the stepchildren in the home, hers from another marriage or another relationship, may reflect the fact that she's been elsewhere. His compromised masculinity and humiliated fury, as I refer to it sometimes, is something that may apply significantly more in cases of sort of pit bull type offenders, but nevertheless may be pertinent in the cases of antisocial personality disordered batterers as well. And we don't have so much research on that, the way in which psychopathy results in the processing of emotion in the same way, and the dealing and discharge of shame, but there is some research currently going on with that. So we see these things, and we note too from research of many other folks, all of the other psychological issues involved, emotional harms in these cases that may far transcend and be far more injurious and harmful than actual acts of violence. So we see the isolation from family, friends, and others, degradation, humiliation, the belittling, the abuse, the sexual humiliation and exploitation, the exploitation of labor, regulation of daily movements, surveillance, deprivation of liberty. Evan does a really nice job of this in his book on coercive control. And in later work, Evan actually points out that the level of control may be a better predictor than prior assaults of future sex assault and homicide. So clearly, we've got a plethora of issues in these cases that are, very difficult to unravel for the judge with limited time on the docket to hear one of these cases with all the presenting complexities and counterintuitive behaviors. So a lot of people like to refer to these behaviors as strategies, and they may well be, and they often are, tactics and strategies engaged in by abusers. but they may not be sometimes. And I think it's incumbent upon us always, and we always encourage our fatality review teams to ask this question, you know, how do we really know what we know? Because when we talk to men who've killed, when I talk with men who've killed their abused partners, it's less clear that what they were doing was strategizing. Now, are they bullshitting me? Are they lying? Are they forgetting? Yes, of course, it's possible all that's going on, but there is a literature which says that there may genuinely be not the same level of intent that we might like to infer from the victim interpretation or the advocate interpretation of the behavior that the perpetrator was perceived to be engaging in. So these are complexities, and again, these are complexities that the court has to unravel. So unraveling them is very difficult at the level of the psychodynamics, so hence the risk assessment tool gives us clear, precise indicators potentially of harms that we may be able to condense and congeal into something usable and quick. So the intimidation issue here I've already talked about, but it may be that abusers have intimidated sufficiently in the past that they don't need to use violence. They just need to look at someone. And we see this too. So we see, as I mentioned earlier too, the gaslighting stuff, the anonymous threats. You know, we've all heard these things, you know, the click of the handgun at the end of the phone line, the sabotaging of electronic communication. All these examples that I've got here are taken from case reviews I've done in death reviews, but, you know, stealing money, cutting telephone wires, gluing locks, making women feel crazy, all this stuff goes down. And again, without evidence that traces it specifically to someone else, this is complicated to present in a family court arena. So, enough said on that. Let me get now to the final section of the presentation and look at whether or not risk assessments might be helpful in family court arenas. So, for example, and this is a question really, would more information about dangerousness or potential dangerousness in IPV cases enable family court judges to make fairer, safer, and appropriate decisions regarding parents and children? Most judges that I talk with, and when I do judicial trainings or, you know, work with them in the field around death reviews or committees or whatever it is we do, you know, most judges would say that more information is better, and better still if there's evidence to back it up, obviously. But if there is clear information to process, that is helpful. Specific acts, justified, verified with evidence, is valuable. What kind of information might family court judges need, and what's the best way to provide it? And can family court judges routinely assess danger based on the facts and the evidence they've seen and heard? And if they do, how should they properly use that assessment? I mean, these are very important due process questions, and they affect the rights of both parties. And it's very, very important to emphasize that when you start injecting this stuff, you do start to change the relationship of these cases and the court and the rule of law. There's a really important alteration in the balance of these things if we start putting this stuff in. So I want to say a few words first, as I usually do, about risk. We're in the midst of the early stages of a risk revolution in the criminal justice arena and also in the civil arena. Clearly, we're in an age of risk. The sociologists have been writing about this since the early 1990s. And the idea is that societies can reduce social harms by applying specialized knowledge for preventive purposes. So we see this with cholesterol and people counting their freaking steps and whether they do enough steps per day or something. And we see it too in the arena of dangerous relationships. The one thing that I think the domestic violence movement has not done a very good job of, that we need to do a better job of as researchers, as practitioners, is to understand the difference between relative and absolute risks. Relative risk refers to the risks that a victim faces if they've answered, a high number of yes questions to risk markers compared with a victim who has answered a low number of yes answers to the same risk items. That's relative risk. Absolute risk refers to the absolute chances over time that a victim who enters a high-risk category will actually experience the outcome allegedly predicted by the risk instrument, and that's very different. We've not done a good job of doing that. We need to do a better job because of the due process implications of this stuff. We have a deep desire to predict the future. We live in uncertain times. We live in very anxious times. We live in times where we have to triage shrinking state resources. So risk assessment tools may be helpful, but they may also be a shortcut and a way of accepting diminished state resources for a very, very important form of social harm that we need more resources to address. So that's the flip side of this. It's very important with the notion of risk to specify what we're talking about. Risk of what? We like to talk loosely about lethality assessment. Risk of homicide. Homicides are extraordinarily rare. We cannot predict them. It's as simple as that. There are maybe 1,500 homicides a year in this country if we count the dating violence deaths. There are 1 million to a couple of million assaults depending on how we count our intimate partner violence assaults. Do the math. The odds of getting one of those that ends up in a homicide are very, very, very slim indeed. So we can't predict homicide. We've got a better chance of predicting something with what the statisticians refer to as a higher base rate. In other words, it occurs more frequently. So assault or reassault, maybe even severe reassault, those are easier to predict than the homicides, which are impossible to predict, whatever people might like to tell us. Then we need to think about risk to whom. In the family court arena, is it risk to the female victim, usually the mother? Is it risk to the male victim? Is it risk to the children, to agency personnel, to the judiciary, the court, etc.? And another important question is, how long does this risk last? We have very limited resources. How long do we triage for? Fortunately, the research data tells us that the period around separation seems to be the most dangerous, particularly the first sort of 72 hours or so, and certainly the first couple of months appear to be the most dangerous times in terms of the homicides. But nevertheless, killings do occur much later in time, and because family court cases tend to be drawn out over a longer period of time, they may be more susceptible to a longer term threat involving stalking and surveillance as the case unfolds and gets nastier and nastier potentially. So with the family court arena, this question of risk for how long may be something that we need to pay close attention to and that we need more research on. So I've already talked about this. We talk about risk assessment is healthier and more logical than talking about lethality assessment. Now, there are 3 types of risk assessment, and we'll just briefly mention these. One is clinical, sort of professional judgment opinion. Someone who does this work all the time, sits down, listens to the case details and said, yeah, this is dangerous or this isn't. This has an X percentage chance of happening, versus this case over here, which is more dangerous. If we're just doing this as sort of shamanistic, it's problematic, it's not good. It may be better than nothing, but it may not be. The best way of doing risk is to use actuarial or statistical risk markers in patterns consistently. If we can develop risk assessment tools that combine the 2 of them, in other words, use actuarial tools, but have subjective components maybe even with an override box that overrides sometimes, that can add to. In other words, if the actuarial score is low, but the perceptive police officer or the perceptive victim advocate senses danger for whatever reasons, then they highlight the case as a more dangerous case potentially based on their gut feeling and refer for further services. So that combination of clinical and actuarial we refer to as structured professional judgment. So the emphasis here is on evidence-based frameworks and consistency, but with a touch of flexibility as well, because we know that our experienced officers, our experienced advocates have instincts and we should trust them too. A great example of an assessment tool is Jacqueline Campbell's pioneering work, the danger assessment tool, where she, I think, beautifully recommended women calendaring incidents, logging them over time, weighting them with a severity notation attached. She developed this 20-question instrument used by many, by law enforcement, healthcare professionals, DV advocates. This is one example of an assessment tool. It was developed out of a comparison between a death group and a control group. You can see here the details of those groups. This was a landmark study. You can see it compared 220 death cases with 343 cases of abused women. It was cross-sectional, in other words, it was one point in time. It was not prospective in the sense that having predictive capacities based on the differences between the groups. In other words, it looked at those particular two groups in time. So this was a very important pioneering study published in the American Journal of Public Health. It saw information in the death cases from proxy informants, in other words, people who knew parties. We need more of this research. We need to use more proxy informants to get information on what happened before death. But clearly, in these cases, the intimate femicide cases, the 220 of them evidenced just under 8 yes responses. However, among the 343 control group cases, the average score was just over 3. 83% of women killed scored 4 or more yes, but almost 40% of the women who were not killed also scored 4 or more yes responses. So you can see this isn't a perfect science by any means, but it's a huge progression on what we've had before. The lethality assessment screen was developed by the Maryland Network Against Domestic Violence, operationalizing Dr. Campbell's work in the field. And I won't belabor this, but this is one example. And the idea here was to connect victims with services, to flag some cases. It's not part of the criminal investigation, it's a supplemental safeguard measure. So, as I say, I'm not going to dwell on the details of the LAP. Another example is the SARA, the Spousal Assault Risk Assessment. This is a 20-item checklist, helps criminal justice professionals assess the degree an individual poses as a risk to a spouse, a child, or other family member. This is in some ways more generic. It's not about IPV. Again, the items were derived from the research literature on domestic violence and from the clinical literature on male perpetrators. All of this research has been done on male perpetrators, especially the homicide stuff, because the N sizes with female perpetrators are low. So the SARA, as it's called, looks at things like criminal history, psychological adjustment, spouse abuse history, stalking behavior, etc. The ODERA is an actuarial tool, and basically what the ODERA measures is the likelihood that a domestic violence offender will re-offend. Also predicts the time until a new assault, greater severity of the new assaults. Developed from an analysis of 600 cases used by police officers. So these are the things that are on offer. With the ODERA, 13 yes-no items identify a perpetrator's history. You can see there what those are. A score of 7 out of 13 or more places the man in the highest risk category. Of those, 70% had reoffended within 5 years. That's a high percentage reoffense rate. Now you'll notice the reoffense time is 5 years, so it's high. The outcome measure is reoffense. So reoffences occur much more frequently than, say, homicides. 5 years is much longer than, say, 1 year or 6 months. So you can see how our ability to positively predict which one of these flagged cases will result in the outcome that we're measuring for, depends upon the nature of the outcome itself and the period of time over which we're measuring it. If we measure over a longer period of time, we may be more likely to capture more positive cases. We may. 0 places a man in the lowest category. 11% of men fell into that category, and of those, only 5% had reoffended within 5 years. So again, you can see some important discernible differences. We worked very hard in Arizona over the last 10 years, really, to develop our own risk assessment tool and to work with the researchers, leading researchers in the field on this, Dr. Messing, Dr. Campbell, to try to develop what we've referred to as a community-informed risk assessment tool, which we've called the APPRAISE, the Arizona Intimate Partner Risk Assessment Instrument System. It's a tool and protocol. We've drawn our questions from Dr. Campbell's research. We've asked Dr. Messing to validate this with a data set she's developed in Oklahoma, which she's done. But we basically used 40 years of descriptive statistics from the research, and we worked with a community in Yavapai County, Arizona, which has the small towns of Prescott and Prescott Valley, each with roughly 40,000 population in each of those areas. So we worked with the presiding judge, Judge David Mackey, in that community, the county attorney, Sheila Polk, with defense counsel, with prosecutors, and with the police departments to build over 3 years this tool. We had tremendous assistance from the advocacy community, domestic violence programs in the community, and we also developed this in conjunction with the coordinated community response team in that community. So this was a true community initiative in terms of the selection of the questions, how many questions there are, how we would deploy this on the street, in shelters, in other settings, and what it might mean. And this tool that we developed became the Yavapai Risk Assessment Tool, and eventually became the tool that we would use in the state of Arizona to develop a statewide risk assessment tool. So we used a lot of research on this, and we relied on research that was cross-sectional. Campbell's landmark, very important study. We relied on Snyder's research published in 2009 and Jill Messing's research published in 2015, which tracked cases over time. And they tracked the impact of a risk assessment intervention over time to see what difference that made to the outcomes. So the focus for us in Yavapai County was on the risk of severe reassault, which included near-lethal violence and the homicides. So the standard was high, severe reassault. It wasn't just reassault. It wasn't a first-off assault. It was reassault of a severe kind. And we took our lead here from some of Jill Messing's research, particularly some great research she published in 2015 using non-equivalent groups in a sort of quasi-experimental field trial using 3 different groups. What she found was, and I won't bore you with all the details, but if you want to email me, I'm happy to send you that research as an attachment if you want to read the full thing. But what she found was, Jill and her team, that the administration of the lethality assessment program, that risk assessment that the Maryland folks developed earlier on, was associated with an increase in potentially protective actions by victims and a decrease in the frequency and severity of violence among this particular sample of survivors. So an increase in potentially protective actions might mean things like building a safety plan, hiding the abuser's weapon, developing communication codes with other people as part of a safety mechanism, removing oneself from the scene, eliminating one's exposure to the abuser potentially. So these were examples of the kinds of protective actions that increased as a result of administering the lethality assessment program by police, and that increased over time. And the time span that Dr. Messing looked at in this research was sort of 7 to 9 months. So we used that in our research, and she had this data set with 619 cases in the state of Oklahoma. And there was also an association between the administration of that tool and a decrease in the frequency and severity of violence. That struck us as very compelling and potentially very important. So we thought that had great potential for victims and potentially of great value for the court systems, whether it be family court arena, whether it be even the criminal court arena, for accepting this information for initial appearance of the offender or the suspect or the accused. So we developed 7 questions with the community that the community chose, and we put those into a tier 1, and I'll show you this tool in just a moment. And then Jill ran all of our questions that the community wanted, many of which they wanted to put in a tier 2, which was a sort of an optional tier for questions. And Jill ran all these questions and identified the 7 most significant questions, which she ran and validated through that data set in Oklahoma. So this is the appraise tool, as you can see, and this currently is being used in the state of Arizona by about 35 police departments, and it's being taken up and recommended for use by ASPOST, our Law Enforcement Peace Officer Training and Standards Board. It was recommended for use and recommended as validated by the Arizona Supreme Court in December of 2017, and recommended for deployment starting April 2nd of 2018. So now what we have is the attempt to produce a unified risk assessment tool in the state of Arizona using this model. And you can see here these questions are questions that I've broached before in some of the research. These obviously are questions that law enforcement officers ask at scene, that victim advocates may ask on follow-up, but you can see there's a simple yes, no, or decline box. We didn't use a refusal box because we knew that conveyed a sense of the victim being potentially hostile, which we didn't want to do. We use that language, and you can see here that yes to 2 or 3 tier 1 questions signifies elevated risk. Yes to 4 or more tier 1 questions signifies high risk. And we'll just look at tier 2. Tier 1, if you're a police department and you are, as a matter of policy, using this tool, tier 1 is mandatory for police officers to ask at the scene, but is obviously voluntary for victims. Victims don't have to participate in this at all. These questions are asked after the establishment of PC probable cause, or they're asked after the arrest is made. They may be asked if the offender has gone on arrival. They may be asked if there's no PC to make the arrest, depending on the circumstances, if the scene is secure. But this produces a lot of information at the scene. So this is the predictive component. This is the contextual component, tier 2, which provides a lot of background case information. You can see here on the action boxes at the bottom, we've still got our clause here, victim referred for follow-up based on responses to the assessment. That's the actuarial piece, but we've also got victim referred for follow-up based on the officer's professional judgment. That's the clinical piece. It's the clinical override based on officer experience and wisdom. So this is the essence of the tool. This next slide, I think, is probably the most important slide that we're going to show you today. And I'm well aware that my time is diminishing, so I'm going to try and wrap this up now fairly quickly, because we do have a number of questions. But I want to go back to what I said at the start. The relative risk, the power of the appraised tool or the power of any of these validated tools, is partly in their ability to help us triage, to identify perhaps potentially the most serious cases. So with the appraised tool, if the victim answers 4 or more questions out of 7 yes, right? So that includes prior attempts to kill you, abuse during pregnancy, escalating violence, maybe use of a weapon, etc. This is very heavy stuff. This is not situational couple violence. It's intimate terrorism usually. It's coercive control, whatever you want to call it, whatever your typology is. But it's serious, heavy stuff. That victim who answers yes, 2, 4 or more of those questions has a 10.5-fold great chance than someone answering less than 2 yes, in other words 0 or 1, of experiencing severe reassault or near lethal violence within the ensuing 7 months from the presenting offense. That's a very serious, useful triaging intervention. But in the interests of due process and the potential use of this instrument or any other instrument in court, we also need to acknowledge the absolute risk. And this was something that the Arizona Supreme Court Committee insisted was put onto the attachment to the appraised form that the officer uses and that goes to defense counsel and prosecution and the judge at initial appearance of the accused. This explanatory language and the absolute risk language is in there. Among victims who answer 4 or more yes, out of 7, roughly only 15% will experience severe reassault or near lethal violence within the ensuing 7 months, compared to those who answer 0 or 1. That is a very different statement to the relative risk. And that is a statement the defense counsel need to hear. It's a statement that relativizes the level of danger and that we think serves the best interests of fair justice and would be relevant for use in the criminal and the civil court arena potentially. Both statements are accurate, but if you only hear the relative risk without hearing the absolute risk, we may develop an exaggerated sense of longer-term risk of severe reassault. We must consider fair justice implications if we're going to use these risk instruments in courtroom settings, whether it's civil or criminal. We have to weigh the issues of defendant freedom in the criminal arena versus victim safety. We have to weigh the issues in the civil arena of the implications of using these instruments. So we don't want to paralyze victims, we don't want to alarm them, but we want to be honest and straightforward with them. So with that, I would invite you to pose a few questions. I know we have more than I can answer, but I will do my very best in the next 6 or 7 minutes. One question is, can Dr. Websdale answer how risk assessments can and should be used in family court? And the answer to that simply is that's a work in progress. I think it's something for administrative officers for courts to decide. It's for judges, for court administrators to decide in conjunction with researchers and others. I think weighing the issues that we've talked about are important. I think we cannot, obviously, as the questioner well knows, interfere with the impartiality and neutrality of the court and the issues of fairness. So it may be that navigating these systems with resources such as court navigators to help in family court may be one way of going with this, but clearly we're not suggesting that court clerks give hints or give suggestions about how to do this. We're not suggesting any kind of slanted interventions here in order to do this. So that's, I'm afraid, the best short answer I can give. I was lucky enough to serve on a commission in Arizona where we just issued a report. It's on the Arizona Supreme Court website on domestic violence and mental health. It was a 5-member commission, and it deals with DV and mental health, where we address some of these issues of risk assessment, fatality review, information from fatality reviews, how we might use court navigators, how information might better circulate, how we might create a sense of what's better needed in family court in terms of evidence, how we might support safety planning, evidence acquisition, but still be fair in court and acknowledge the genuine pain of others, including men who are subject to these disputes as well. So the second question is, does research support using risk assessment in filing orders of protection for judges to consider in making ex parte decisions? In our jurisdiction, these are then served to the respondent for context. Well, if I'm understanding the question correctly, I would strongly encourage the questioner to shoot me a quick email at the address that I've got up on here, and I will send you a copy of the article, the Nichols Hadid article that I mentioned earlier. I think that the research, as I said before, is in its infancy. Is it useful for filing ex parte affidavits? Yes, I think any detailed information from any victim, especially if it's supported by corroborating evidence, would be helpful in terms of submitting your case to the court. So yes, it would be. Are the courts in the business of doing it? No. Or victim advocates who support victims help do this without suggesting or leading victims in certain directions. Those are difficult advocacy questions that I think await further research. But let me move on to another question. Is this tool used at other times than at the police initial response? And this is a question concerning the appraise tool, but it could equally apply to others. Yes, the tool is used. It's used by patrol at scene, as I said, after PC is established, after an arrest or a GOA. In Arizona, the tool under ARS 13-3967B5, the judge is required to consider the results of a risk or lethality assessment at the initial appearance. So if that tool flows through the system, it does get to the judge, but victim advocates can also use this tool with greater luxury of time and relationship and rapport building potentially. So yes, others do use it. We've had hospital emergency rooms consider this for use, and obviously this could be used in other settings as well. So the short answer is yes, it can be used elsewhere. Another very good question: how do I account for the potential for increased danger to victims versus the potential benefit? There's no accounting for that. We need research on this. This is why I say this stuff is in its infancy. This is why I use the language, for example, of potentially protective actions. We don't know if hiding his gun in the long term works better or worse for victims, because we don't have adequate research on that. So we need much more research on that. I think that the key with doing risk assessments is that they have to be conducted out of community initiatives in conjunction with safety planning, and safety planning that takes into account the baseline in these very dangerous cases, and that is, you can never know what these perpetrators are capable of in their heads. If you bear that in mind, you may have more luck, but I'm not suggesting that the risk assessment is a panacea. We don't know that. Jill's initial research, Jill Messing's, suggests that there's a reduction in recidivism, but we need much, much, much more of that research. We need to question it over time, etc. On to the next question. How can this risk assessment used to validate allegations of domestic violence in family court, to assess protective parents versus parental alienation allegations? You know, I don't have time to answer that. It's a very good question, but I will say that the use of the tool improves victim survivor assessments of their own situation. It likely feeds better safety planning. It likely feeds the development of more comprehensive case files, more detailed police reports, potentially better prosecution, potentially the acquisition of better evidence, better photographs over time, etc., and might lead to the encouragement of victims or, you know, those who are involved in family court cases to take more evidence to court. It might. But again, we don't know that. We're just playing around with this stuff, but we need to do more. And I'm sorry I can't answer your questions better. We're way out of time. My IT guy Ray is telling me that I've got to stop. So thanks very much for joining us today. And please feel free to reach out to me by email and